All right, thank you everybody for joining today. We have a great presentation on laying the foundation for appellate success. So I want to make sure we get to that presentation and leave as much time for it as possible. But first, a few housekeeping items. You will receive your MCLE certificate shortly after the program. Your certificate will also be stored in the BHBA Plus, our members only community. So please take a moment to complete the survey which is included with your certificate. Next, I want to introduce our fantastic sponsors. So first, I will start with Nancy Sanborn and Brian Joy from the Sanborn team.
You're muted.
Thank you for that. First, Nancy and I want to thank you for the privilege of your time.
We want to give you a quick market overview and update with what's been happening with the Sanborn team. People always ask us what's happening with the market, and we can certainly say this market is pretty interesting. The best analysis I can give you is that my husband recently sold a car. It was quite interesting. The dealer offered him $13,000 for the car. He put a sign on it and ended up getting $20,000 for the car, and then looked at the car again and said, my goodness, now it's worth $22,000. And kind of the same thing is going on with housing. In 2021, we reviewed a staggering 900 offers on our properties. It was pretty crazy.
We recently had 2 properties in Inglewood that received over 90 offers on each, and ultimately sold to an investor who plans on flipping them. 2 weeks ago, we went to court to confirm a sale on a property, and it was overbid by $550,000. Suffice to say, the state of the market is strong and should remain strong in the coming months.
So enjoy the program. Thank you for your time.
Thank you, Nancy and Brian. Appreciate that and appreciate your continued support. Next, I'd like to introduce, well, not introduce, but tell you about our sponsor, Geffen Real Estate and Orit Gadish. Geffen Real Estate specializes in representing trustees, administrators, and executors in the sale of residential and commercial real estate. Orit and her team renovate properties strategically with payment made through escrow to allow for their clients to maximize on the return of each sale. Geffen Real Estate sells properties throughout the state of California, currently working on properties as far north as San Leandro and as far south as San Clemente. Orit is an author for the CEB and is also the author of the Practitioner's Handbook for Probate Real Estate, which is available on Amazon. Check it out. The link to the book is in the chat box. And if you're interested in reading it and providing a review, please text Orit and she'll send you a complimentary copy. A few more sponsors in addition to the Sanborn team and Geffen Real Estate. The Trust and Estates section is also sponsored by Glen Oaks Escrow. Marcine Klein is a full service escrow officer specializing in probate, trust sales, conservatorship, and both court and independent administration of estate act transactions. On a daily basis, Marcine works to ensure that even the most challenging escrows close smoothly and that her clients are beyond happy with their experience at Glen Oaks Escrow. Next up is California Title Company. California Title Company provides comprehensive and timely title insurance protection for home buyers, including first-time home buyers, sellers, veterans, and military personnel, seniors, real estate agents and brokers, mortgage lenders, and commercial real estate professionals. Finally, we have Manufacturers Bank. Simplify your banking. Let Manufacturers Bank do it for you. Manufacturers Bank has a dedicated trust and estate banking team with the experience to handle all of your banking needs. Contact Brian Flores, Vice President and Senior Relationship Manager, for more information. One other housekeeping item I'd like to mention is that the Beverly Hills Bar Association recently created a mentor program that connects seasoned attorneys with young attorneys who are interested in their practice area. So if any of you or anyone you know is interested in becoming a mentor, or if you know a young lawyer who would like a mentor, please reach out to Beth Acevedo. She's one of the members of our executive committee in this trust and estate section. So now that those housekeeping items are all done, I want to introduce Courtney Patton, who will discuss the legal updates.
Good afternoon. The first update I have for you is Smaldino versus Commissioner of Internal Revenue, Tax Court Memo 2021-127, filed November 2021. In this case, Mr. Smaldino owned multiple rental properties in Southern California, which he transferred to an LLC. In 2013, Mr. Smaldino transferred about 8% of the LLC's Class B membership interests to an irrevocable trust that he had created for his children and grandchildren. To utilize his wife's remaining unified credit, he then transferred 41% of the LLC's Class B membership interest to Mrs. Smaldino, who retransferred them to the irrevocable trust the next day. On his 2013 gift tax return, he reported as a taxable gift only the approximately 8% of the LLC's Class B membership interests he had transferred directly to the trust. On audit, the IRS took the position that Mr. Smaldino had made a taxable gift to the irrevocable trust of 49% of the LLC's Class B membership interests, including the 41% interest that he had passed to Mrs. Smaldino first. Many facts were presented in support of the IRS's position that Mr. Smaldino never intended to give the interest to Mrs. Smaldino, and that the quick transfer was just a way to avoid tax and was never, and to use Mrs. Smaldino's gift tax exemption. For example, the LLC operating agreement was never updated to reflect Mrs. Smaldino's interest, even if temporary, and the LLC's income tax returns did not reflect her ownership either. Mrs. Smaldino also testified that before the transfer, she had made a commitment, a promise to her husband that she would transfer the LLC interest to the irrevocable trust. Mrs. Smaldino testifying that she had no intent to hold the equity interest contradicted the purported substance of the transaction of her accepting ownership of the interests. The tax court agreed with the IRS, concluding that based on the circumstances, Mr. Smaldino never effectively transferred any LLC membership interests to Mrs. Smaldino, and consequently, the irrevocable trust received its entire 49% of the Class B membership interest as a gift from Mr. Smaldino. The second update I have for you is a recent formal opinion from the State Bar Standing Committee on Professional Responsibility and Conduct. This is Formal Opinion 2021-207. In this opinion, the Standing Committee interpreted several rules of professional conduct to determine the ethical obligations of a lawyer or a client with diminished capacity. In interpreting these rules, the Standing Committee found that a lawyer for a client with diminished capacity should attempt, insofar as reasonably possible, to preserve a normal attorney-client relationship with the client. That is, a relationship in which the client makes those decisions normally reserved to the client. The lawyer's ethical obligations to such a client do not change, but the client's diminished capacity may require the lawyer to change how the lawyer goes about fulfilling them. In particular, the duties of competence, communication, loyalty, and non-discrimination may require additional measures to ensure that the client's decision-making authority is preserved and respected. When the lawyer reasonably believes that the client's diminished capacity exposes the client to harm, the lawyer may seek the client's informed consent to take protective measures. If the client cannot or does not give informed consent, the lawyer may be unable to protect the client against harm. The key conclusion in that opinion is a lawyer representing a competent client may propose to the client that the client give advanced consent to protective disclosure in the event that the client later becomes incapacitated and that incapacity exposes the client to harm. If appropriately limited and informed, such a consent is ethically proper. And with that, I will turn it over to Dina.
Thank you, Courtney. Hi, everyone. I have the distinct pleasure of introducing our speaker, Alana Rotter, today. Before I do so, I just wanted to remind everyone there is a Q&A button at the bottom. So if you have any questions for her, please put them there and we will get to them at the end of the program. Alana Rotter is a partner at Greines, Martin, Stein, and Richland. She's an experienced appellate attorney who is a certified specialist by the State Bar of California. She has successfully worked within the California appellate court system, as well as within the federal courts, specifically within the Ninth Circuit. So she brings with her a wealth of experience that we really are excited to have her today and learn from her. So without further ado, I'd love to have Alana speak, and we look forward to having her here.
Thanks, Dina, and thank you to everyone. I'm here today to talk to you about things that you can do in the trial court or the probate court, or not do in the probate court, that really impact your chances of success on appeal, whether it be trying to preserve a victory or to overturn a loss. And I'm going to start with the caveat that I can throw a lot of advice at you today, and I recognize that I'm doing it from the position of sitting in kind of an ivory tower where I'm looking after the fact at what happened. And it's very easy for me to say what should and shouldn't be done in the probate court or in the trial court level, but that it's a totally different matter when you're actually litigating your case there. And there are many strategic considerations, and the pieces are often moving quickly. And so none of this is designed to tell you what you must do in any given situation or what's the right strategic choice. But I want to at least make you aware of considerations so that you can factor them into your decision making, hopefully have them in the back of your mind. And to the extent you're not following any of these pointers, there's a reason to do it. It's not just because you weren't aware of things. So with that said, one of the two most important principles, I would say, in terms of appellate perspective, is making a solid record. The other one is appealing on time, which I'll get to later. But on making a solid record, there's a quote that gets used a lot, quoted back at people in opinions. When practicing appellate law, there are 3 immutable rules. First, take great care to prepare a complete record. Second, if it's not in the record, it didn't happen. And third, when in doubt, refer back to rules 1 and 2. So if it's not in the record, it didn't happen. And this can come up a lot of ways, how something comes to be not in the record. One way is that there was no court reporter present when there was a conversation being had. Court reporters used to be a given, and then they became something you had to organize for yourself. So there's that step of needing to have a court reporter present. But there are also often conversations that don't get reported, whether it's because a reporter wasn't there at all, or because something happened at a sidebar or in a judge's chambers. So step number 1, make sure there's a court reporter and that reporter is reporting when you're having important discussions. If you're having a sidebar or something else where there is no reporter present, once you are back on the record, it's beneficial to summarize what happened. We went to chambers, we agreed X, put it on the record so it will be there. Again, if it's not in the record, it didn't happen. And I'm seeing this right now in a case I have where the parties were before one judge and they had a bunch of discussions. No one had a reporter there. The case was transferred to another judge. And one of the parties keeps saying, but we agreed. And the court says, show me where. And there's nothing in writing to document the agreement. So court reporter is important. If it's not in the record, it didn't happen, also can apply to witness testimony. Something that a witness says may be very clear to everyone in the courtroom, but it may not be clear at all to someone who wasn't in the courtroom, i.e., an appellate lawyer, an appellate justice, a research attorney. So if a witness is testifying, it was this big, he went over there, this document, this paragraph, all that might make sense when you're in the courtroom and you can see where the witness is pointing, what image is up on the screen that they're agreeing, what they're signaling. But someone later has no way of knowing what those gestures were and what was happening. So a way to fix this is to try to be cognizant when you're listening to the testimony, would this be clear to someone who had their eyes closed right now? And if it wouldn't be, you can ask questions or add statements to clarify. So, oh, you're pointing towards Mr. So-and-so. You're looking at paragraph 3. You're estimating about 3 feet. You're pointing to the left. Things like that, where you're narrating what the witness's gestures were, or you can have the witness just rephrase their answer to be more definitive. Another way, if it's not in the record, it didn't exist, is video depositions that are played at trial. These are becoming increasingly common. The default is that a court reporter will not transcribe what's playing on the screen in a video deposition. The judge generally relieves them of the obligation to do that. So if the video is played, there's a hole in the transcript where it won't be clear what was played. How do you remedy this one? The California Rules of Court, Rule 2.1040, requires lodging a transcript of what was played. You can also, in addition to lodging the transcript, it's good practice to say on the record or to indicate in that lodged transcript which line and page numbers are being played. So later on, someone working on the appeal can have that transcript in their hand and see exactly what was played, and that becomes part of the record. If you're in a situation where you already had a trial and now you're on appeal and you didn't do this, a fix that we often are able to use is to try to reach a stipulation with the other side as to what was played and to augment the record to include those excerpts and complete the whole. The Court of Appeal will allow this kind of augmentation. The Court of Appeal is interested in there being a complete record if it's possible. So that's an after the fact fix, but even better is just have the transcripts lodged at the time that they're being played. Going back to, it's important to have a reporter. In addition to having the reporter there, later when you are up on appeal, it's important to know which of the transcripts that you had reported are going to be relevant to the appeal and to make sure to include them in the appellate record. As an example of what happens if you don't, there's a case called Keating versus Keating. This is a probate elder abuse case, 60 Cal App 5th 1115. In the unpublished portion, but I'm just using this as an example, one of the parties wanted to argue that the court erred in denying certain limited discovery. And this party didn't put a copy of the transcript in the record where she requested it and where the court denied the request. And the Court of Appeal says, sorry, you forfeited your argument. We needed a reporter's transcript to have a complete record. On appeal, all presumptions are in favor that the trial court got it right. So absent a transcript, we're going to assume that whatever happened at that hearing was right, and we're not even going to reach your argument. This is a very common appellate move, to find something forfeited for the lack of a transcript showing what happened. And so you want to make sure you've created that record in the trial court by having a reporter, and that it gets to the Court of Appeal. So moving on from creating your record, you also want to avoid forfeiting or waiving arguments inadvertently. People want to sound agreeable. The court's kind of pushing you to do something. You want to move on. You say, okay, Your Honor, we agree, or okay, Your Honor, that sounds fine. This is language that later can be used against you as a concession. So you want to be careful with your phrasing when you've lost and you're ready to move on, but okay, Your Honor, we disagree, but we understand your ruling. Something along those lines that can't later be twisted to, oh, you're acceding to the court's ruling and now you think it's fine, in which case you won't be allowed to challenge it on appeal. You also want to do your best to preserve whatever the good issues are likely to be. Now, this is one of those ivory tower kind of things where it's easier on appeal with the benefit of hindsight to know what the arguments were that were important to be raised. But in general, arguments that were not raised in the trial court on the record cannot be raised for the first time on appeal. And so you want to be careful to think about and gather your best arguments and to make sure that they're in writing somewhere or verbally on the record if that's appropriate, so that someone can pick up those threads later and run with them if necessary. An example of this, I worked on a series of appeals involving a trustee who was doing everything you could possibly do wrong with the trust and taking trust assets. And we came in for the successor trustee to try to clean things up. And the former trustee, we went through 3 or 4 rounds of appeals with him throwing up new arguments every time. And in the second appeal, he came up with a new theory about judicial estoppel, and he hadn't raised that below. And so the Court of Appeal said, sorry, we're not even going to consider it. And in the third appeal, he came up with an equitable estoppel theory, hadn't raised it below. Court of Appeal says, sorry, we're not going to consider it. So there's occasionally room on appeal to try to maneuver a new argument if it's a pure legal argument, But in general, the best practice is to have raised the argument below in your papers and verbally to the extent necessary. Turning to motion practice. A key, I talked to a court staff to see what input they had on this general topic. I said, make sure you ask for the relief you want very clearly in your prayer. Parties often are not as clear as they could be. And then the minute order is drafted to reflect the prayer and it's not in the minute order. And later you want to go up on appeal and argue that you were denied the relief you sought. We go back and look at the prayer and it's not actually there. So look carefully. It seems like kind of a catch-all at the end, but make sure the relief that you want is there so that you have an opportunity to argue later if your relief was denied, that it shouldn't have been denied. One area to think about in probate motion practice specifically is anti-SLAPP motions. Some of you may have seen me do a couple of presentations on this elsewhere. Anti-SLAPP is an animal unto itself, but exists in probate, and especially with petitions to enforce no contest clauses. They will always trigger an anti-SLAPP motion. For those who don't know what an anti-SLAPP motion is, in a very quick nutshell, it's like a motion to strike. It can throw out certain causes of action or even entire complaint or petition right at the beginning of the case. It's filed within 60 days of the petition or the complaint. So if you're working in a case where there's going to be a petition to enforce a no contest clause or any other kind of petition based on litigation, based on positions that were taken in court, based on public statements on an issue of interest, expect an anti-SLAPP motion. It's likely to come. And the reason I say expect is because what can you do? Well, when an anti-SLAPP motion comes, it stays discovery. So if you know one is likely to be coming, you want to get your ducks in a row as well as you can before you file your petition or your complaint, so that you have ammunition once the other side files an anti-SLAPP motion. You're going to have to show a reasonable probability of prevailing on your claims. And that's going to take evidence. So if you've gathered your evidence in advance, you'll be prepared to meet the burden. If you haven't gathered any evidence in advance, it can be hard to make that reasonable probability of success showing once the motion is filed and discovery is stayed. And I mentioned this from an appellate perspective also, one is just it's a heads up for anyone litigating, but from an appellate perspective, an anti-SLAPP ruling, grant or denial, is immediately appealable. So if there's an anti-SLAPP motion, you may quickly find yourself in the Court of Appeal. And the Court of Appeal will want to know what evidence there was on reasonable probability of success. So you'll need to have built that record already, so it's there, both for the trial court to see and for the Court of Appeal to see. And again, anti-SLAPP motions are really, it's a whole complex body of case law. If you find yourself in this situation, there's a Rutter guide on it. I'm available as a resource. There's lots of case law. I just flag this so it's in the back of your mind when you're preparing a petition or a complaint that may be susceptible to an anti-SLAPP motion. Another appellate preservation issue is with demurrers. So if a demurrer is stained with leave to amend, and you choose to try to amend, you have likely forfeited on appeal an argument that the initial demurrer ruling was wrong. By amending, you move the ball forward and you can no longer on appeal go back to that prior ruling and say that never should have been granted. You can choose to stand on your complaint as it was and not amend as to the cause of action that was at issue, and then appeal at the end of the case. But beware that if you amend the specific cause of action, that will affect your ability to challenge the demurrer ruling later. Another thing in motion practice is a basic tenet of legal practice generally is good writing. This goes back to, we want to see that all of your good arguments were preserved in writing or verbally in the lower court. So make sure your motion is as clear as possible. This increases your chances of getting your motion granted in the trial court, but also it's helpful from an appellate perspective. Clear headings and clear arguments. If you have arguments that are buried in footnotes or that are just a throwaway sentence, that will likely be treated as not having been raised at all and cannot be picked back up on appeal. So again, after writing a motion is often a rushed practice, and there's page limits to deal with and all kinds of considerations. But bear in mind, it's worth a glance afterwards. Are all my important arguments in headings? Are they developed sufficiently that I can expect the court to notice them and rule on them? This is necessary to preserve them for appeal. Turning from motion practice to trials or hearings on, evidentiary hearings, it's key, again, creating a record. So you want a clear record of what exhibits were admitted and which ones were not. Surprisingly often, this is not obvious. And the only way to figure it out is by going through the transcript and trying to write down a list. Some reporters will make a nice index that indicates. Some courts, but not most, will ask someone to draft a list and keep track of the status of each proposed exhibit. But many cases where I've seen, it's just not clear. And sometimes everyone talks about an exhibit, but it never gets admitted. And then there can be a fight on appeal about, was it before the court? Wasn't it before the court? Did the court make an evidentiary ruling on it or not? So having someone on your team tracking the status of all the exhibits and did we get a definitive ruling on them is important. It can be hard to do in the chaos or the busyness of an actual evidentiary hearing or trial, but at the end of the day is an opportunity to go through with the clerk perhaps and confirm exactly what happened and make a list and keep a running list is a good way to create your record. If you propose evidence and the court will not let you put it in, the court excludes it, make an offer of proof. An offer of proof describes what the proposed evidence is in some detail. So what a witness would testify to, what the document would show, and why it's relevant and necessary in light of the other evidence you're putting in, why it's not duplicative, for example. Without an offer of proof, the appellate court might find that you have forfeited any challenge to the evidentiary ruling. It will also impede your ability to show that any error in excluding the evidence was prejudicial. An error is prejudicial if it's reasonably likely that the evidence would have made a difference. But if you haven't described the evidence on the record and why you need it, it can be harder to show that the evidence would have made a difference. So that's an offer of proof if your evidence is being excluded. If you are objecting to the other side's evidence, the keys are a timely objection on the record with specific grounds stated. And I say this, and I know that you all know how to do this. It sounds like, it sounds like I think you don't, you do. But in the busyness of trial, sometimes things get lost. And so it's very important, timely and on the record. Again, if it didn't happen, if it's not on the record, it didn't happen. So if your objection was in chambers and sidebar, whatever other format where the reporter was not reporting, make sure you get it on the record afterwards. And again, on the specific grounds, you will not be able to raise an evidentiary objection on appeal that was not raised in the trial court first. And in fact, Evidence Code Section 353 prohibits reversal for an evidentiary ground absent an objection on the record. Often the court will defer ruling on an objection. Perhaps the court thinks it's premature. The court says something along the lines of, well, I'm not going to exclude Mr. X's testimony wholesale. We'll cross that bridge when we get there. Or I'm denying it for now, but subject to reconsideration. Anything like that, you need to make a note to keep objecting when the witness comes up or when the testimony ventures into the problematic territory. You can sometimes do this by requesting a 402 hearing, by objecting when the witness takes the stand, by objecting to a particular question. But I've had cases where the court denies something without prejudice, denies a motion to exclude without prejudice, and then the witness gets up and the other side just never renews their objection. Perhaps they lost track. There are many things to keep track of. And then up on appeal, the other side says, well, I objected early on and the court let him testify. And the Court of Appeal will say, well, no, the court, when you objected early on, the court said you were welcome to re-raise this and you didn't re-raise it with the court. And therefore on appeal, we are not going to parachute in and save you. Your time to preserve this was when the witness got up. You didn't do it. The argument is forfeited. I've in fact had entire appeals disposed of that way in my favor. Appellate lawyers like these record kind of preservation issues because it often can short circuit what would otherwise be a very long argument. If you're moving for summary judgment, there will be evidentiary objections there too, of course. The Supreme Court has begged parties to try to be judicious in their use of these objections and not to file hundreds of them, but rather to focus on the important ones. So I communicate that as a repeated request from the Supreme Court in published opinions. But also, as long as you have made the objection in your summary judgment objections, it is preserved for appeal, even if the court doesn't rule on it. The evidentiary objection will be deemed preserved, but overruled, and then reviewed most likely for an abuse of discretion, although there is some dispute in the case law about whether it is always reviewed for an abuse of discretion, which is a very deferential standard to the trial court, or whether some kinds of objections are reviewed de novo, which is not a deferential standard. And so, but either way, the important point is to have made the objection in writing. The other kind of objection that's important to make, although comes up much less in the kind of bench trial and motion practice situations that most T&E lawyers are likely to find themselves in, is attorney misconduct. If you're in a case where the other side's lawyer is making arguments during opening or closing or asking questions that are really run afoul of either specific in limine rulings or general practices, for example, trying to inflame the decision maker with improper considerations, the objection needs to be made basically immediately and on the record. If it's not, the trial court or the probate court can refuse to consider it, and the Court of Appeal will refuse to consider it. And so just by way of example, I had a case where it was a jury trial and the other side's counsel started making what's known as a golden rule argument, which is prohibited. You know, how would you feel if you were in their shoes? What amount of money would it take for you? My trial attorney who I was working with waited until the next jury break to object because he didn't want to interrupt the closing. The trial court said, you waited too long, you forfeited it. And up on appeal, we tried to resurrect the argument, and the court said, yeah, this was probably misconduct, but it's forfeited, no timely objection. And so again, I understand strategically there are many reasons to not want to object during the middle of an attorney's argument, among not the least of which is that the court hates it. But it may be necessary for evidentiary to preserve the issue. And this is one of those things where I'm flagging this is a thing. I'm not telling you whether strategically the right call is to object or not object. It really depends on how egregious it is, how mad the court might be. But it's something to be aware of, that if you let it go, you may not be able to do much about it later. One strategy is to talk to the court in advance. How would you like me to handle objections, Your Honor? You know, I anticipate based on this, whatever track record, that this may be a problem. Would you like a brief in advance? What would you like? And try to navigate with the court. So at least you've alerted the court that you're sensitive to how, you know, its perception, but also that you need to do this to make your record. But communication can go a long way. In bench trials, an important thing to know about is the statement of decision process. And this is a highly technical process. Courts often misunderstand it and don't follow it. Sometimes parties get tripped up. My firm often gets brought in to help navigate this process because there are a lot of steps and it's so esoteric. And it really is setting up the record for the appeal, and that's the main purpose. So I'm going to spend a little bit of time on just what this is, statements of decision. There's also what should be an article in the materials you've been given with today's presentation, laying this out in more detail because it's hard to absorb just in kind of one download right now, especially if you're not in the midst of dealing with it and you're going to run into this a year from now. Just remember, statement of decision. There are issues here I need to be thinking about. So what is a statement of decision? A statement of decision is, the court must explain the factual and legal basis for its decision on each of the principal controverted issues at trial upon a party's timely request. Statements of decision are available in a trial of a question of fact. This means they are not generally available in law and motion matters, although courts will occasionally agree to make one anyway. But we're generally talking about trials. The statement of decision, as I said, explains the court's reasoning. The main reason to have one is that it affects the presumptions on appeal. So I mentioned before that on appeal, the Court of Appeal generally will infer that the trial court or the probate court got it right, that there was a basis for all of its decisions. And even if they're not stated anywhere, the court will infer findings, implicit findings that would make the ruling correct. The statement of decision process is a way to cabin what inferences the Court of Appeal will draw. And here's how you do it. Party requests a statement of decision, proposes various issues that should be decided in the statement of decision. The court drafts or has a party draft a statement of decision. If the statement of decision doesn't address the main issues that the requesting party asked for a decision on, you can, there's an opportunity to file objections. And the objections are not your standard objections of I disagree substantively with the rulings. The objections are, hey, court, you didn't explain the basis of X finding. You didn't explain how you were resolving this issue. Your explanation of this is ambiguous. It's essentially just the statement of decision doesn't explain your reasoning, taking your premise of what was the correct result and what the answer is. The statement of decision doesn't adequately explain the basis for the rulings. If you file those objections, pointing out omitted issues, and the trial court does not go back and fix its statement of decision to address those omitted issues, the Court of Appeal will not assume that the trial court reached all those and made the findings it needed to make to support the judgment. It won't infer findings against the losing party on those issues. And this is helpful because it means that there could be holes in the trial court's reasoning. And then you can point to all the evidence that should have led the trial court to reach a different result. You're in a much better situation than you are in a situation where the court is going to infer implied findings on all these issues. So when you're doing objections to a statement of decision, it's very counterintuitive, at least it was to me. Your best case scenario is that the court ignores your objections, that in response to your objections, it does not touch the statement of decision. It says, I read the objections, I'm good with my statement of decision, it's final. Because now you have points where the Court of Appeal is not going to infer findings against you on appeal. The risk of objections is that the trial court takes them seriously and fixes its statement of decision and shores up its reasoning. And now there are explicit findings, not just implicit findings, but explicit findings that are unhelpful. So there is some risk in your objections, but you want to make the objections just pointing to what was omitted. And again, hopefully, you do them seriously, but your best case scenario is really that the trial court your best case scenario is the trial court changes its thinking completely and rules in your favor. But the more realistic scenario, which is good too, is that the trial court doesn't rule on all of your objections or doesn't fix the statement of decision in response to your objections. And then you've limited the findings that will be against you. A statement of decision must be timely requested if your trial is fewer than 8 hours or less than 1 day. You have to request a statement of decision within that trial time before the matter is submitted. That request can be oral. If your trial lasts more than 8 hours or more than 1 day, then after the court issues its tentative decision, you have 10 days to request a statement of decision, and that must be in writing. So this gives you some luxury because you generally will know if you're going to win or lose before you have to decide whether to ask for a statement of decision. If you are going to win, you probably don't want or need a statement of decision because the default will be that inferences are in your favor. If it's going to be a mixed result or you're going to lose, you probably do want a statement of decision because of the opportunity it presents to limit the inferences that the Court of Appeal will draw. In your request, you would specify the principal controverted issues on which you want the statement. It's not enough just to say, I want a statement of decision, but you would identify the main issues that the court should explain its thinking on. It used to be the case that some courts thought that the failure to follow the statement of decision process was automatically reversible error on appeal. And in fact, I had a case where the trial court didn't understand the process and didn't allow time for objections. And we tried to get the trial, we were the prevailing party, but we tried to get the trial court to fix this because of the risk that on appeal, the Court of Appeal might say, well, that was per se reversible error and send the whole thing back. But the trial court thought it didn't have jurisdiction to fix the statement of decision while there was an appeal pending. This is no longer such a question mark. The Supreme Court said in 2017 that it's not per se reversible error to get the statement of decision process wrong, but it can be reversible error if the absence of a statement of decision or the absence of a chance to object caused prejudice or made it impossible for one party to show error. And so this is still an important thing to get right, but it's not per se reversible error when the court doesn't get it right. That Supreme Court case is called FP versus Monier, 3 Cal 5th, 1099. The absence of a statement of decision can make a difference. I had, in that same case I was talking about before with the bad trustee followed by the successor trustee and the many series of appeals. In one of them, there was a petition for treble damages under Probate Code Section 859 on the issue of whether funds were withdrawn in bad faith. And the Court of Appeal ends up saying, appellant does not suggest that he requested a statement of decision regarding whether he used the account funds in bad faith. Neither does he contend that he brought any omission regarding that issue to the probate court's attention. Therefore, we are free to presume that the probate court found he acted in bad faith. So again, this is an example in practice of the court being willing to draw all inferences in favor of the judgment absent someone following the statement of decision process and objecting that there wasn't a decision on it and sort of cabining the inferences. This is a situation where because there was not one requested and no omissions were noted, the court will draw the inferences against the appellant. Turning briefly to post-judgment motions. Although these tend to be more common in jury trials than in bench trials, you can do them in bench trials. You can move for a new trial, that's CCP 662. The court can change its statement of decision. It can modify or vacate its judgment. It can grant a partial or a full new trial. It can set aside the statement of decision and judgment and reopen for further proceedings. The court has a lot of flexibility. So if something has come to light and you see an opportunity, a new trial motion may be a way to get another shot while you're still in the trial or probate court. A new trial motion is not strictly necessary to preserve most issues for appeal. It really is to maybe get a second chance before the trial court, or if you have a hole in the record, putting in declarations with a new trial motion can occasionally be a way to clean up the record. Makes it, if you haven't made an argument yet to the trial court, you have a new great argument that you thought of too late. Better late than never. So better to put it in a new trial motion and have it at least been before the trial or probate court than to be doing it for the very first time on appeal. The only situations where a new trial motion is necessary to preserve an argument are really specific to jury trials, but I mentioned them in case you have any. If there's going to be a juror misconduct argument, that needs to be made in a new trial motion and supported with declarations or affidavits. It cannot be made for the first time on appeal. And if there's an argument that damages are excessive or inadequate because the fact finder was improperly inflamed by prejudice or bias, that argument also needs to be made for the first time in a new trial motion. That's different than an argument that the court used the wrong measure of damages or made some legal error. That kind of argument generally can be made for the first time on appeal, but an argument about inflammatory bias, prejudice kinds of things needs to be made first in a new trial motion. There are very strict jurisdictional deadlines for new trial motions, both for the notice of intent to move for a new trial and for the court to rule on a new trial motion. So if you find yourself in this territory, it can be a good time to consult the Rutter Guide, the rules, and probably an appellate lawyer. We deal with post-trial motions quite a bit, including helping draft them, but also just navigating the process. And finally, I said at the beginning, the two most important things probably from an appellate perspective are creating a record and appealing on time. So I'll touch on appealability. The appealability deadlines are jurisdictional. If you miss them, there's nothing that any court can do, no matter how good a reason you had. There have been situations where someone missed a deadline because the clerk gave bad information, because a court gave bad information, because the parties thought they had stipulated to extend the deadlines. None of that matters. If you miss your deadline, you miss your deadline. Appeals are generally from a final judgment, which resolves all the issues in a case between two parties. It's different than the federal standard, where a final judgment has to resolve all the issues in a case between all the parties. In California, state court must resolve all the issues between two parties. So if you've got a multi-party case, but all the claims as to two particular people have been resolved, there can be a final judgment in that situation. Generally, an appeal from the final judgment encompasses all of the interlocutory, non-appealable rulings leading up to the final judgment. And so you can raise lots of things, not just what's in the final judgment. And outside the probate and family law contexts, that's generally how it works. Almost everything is interlocutory until you get to the judgment, and then you appeal from the judgment. There are some exceptions outside family and probate. For example, the anti-SLAPP motion that I talked about before, a ruling on an anti-SLAPP motion is immediately appealable. Certain other kinds of motion rulings are immediately appealable. But by and large, in the civil context, you wait for the judgment. Probate and family, I just mentioned because it's similar, are different. There are lots of appealable orders in probate. And if an order is appealable, then your clock to appeal it starts running when the order or notice of entry is sent. And you can't just appeal it later on appeal from final judgment. If something is appealable, it needs to be appealable. It needs to be appealed when it's entered. So the first place to look if you're trying to figure out if you have an appealable order is Probate Code Section 1300. And I've given you copies of 1300 and also of the other relevant statutes in the materials with today's program. But Section 1300.
Oh, Alana, you just went mute.
Sorry, there we go. Allows appeals from orders granting or refusing to authorize, instruct, or direct a fiduciary or approve or confirm the acts of a fiduciary, surcharging, removing, or discharging a fiduciary. There's a long list, but those are a few. 1304 governs appealable orders as to trusts, making appealable the grant or denial of, for example, a final order on a 17200 petition concerning internal affairs of the trust, or a petition on payment of claims, debts, or expenses from a deceased's revocable trust. There are also rules for guardianships and conservatorship orders. But again, the theme is in probate, lots of appealable orders that must be appealed, if at all, shortly after they are entered. And so familiarizing yourself with what's appealable is a good practice. Or if you haven't done that already, if you get a significant adverse ruling, at that point, remembering to turn to the statutes and to check, can I appeal this now, or does this wait? There are also an option of writ petitions. And this is more important, again, in the civil context, because in the probate context, so much is immediately appealable. But if you have a really significant ruling that is not immediately appealable, for example, the court orders discovery of something that you think is privileged, or attorney disqualification. There are things that are really significant and really hard to fix later, because you can't unring the bell once you've turned over privileged information, or once an attorney has been kicked off the case midstream and you don't think they should have been disqualified. This is the time to think about a writ petition. A writ petition generally is due 60 days after notice of the ruling at issue. That is a common law deadline. That's not a statutory deadline. Sooner is better with writ petitions. But essentially what you're doing is saying to the Court of Appeal, this ruling is not immediately appealable. I understand that, but it's really important. It has really significant implications for my case, and I can't, later will be too late. And I'm asking you, Court of Appeal, to exercise your discretion to jump in now and decide this issue. And they're not granted very often, but in the right kind of case, they can be. And they're very technical, a writ petition. So if you're exploring a writ petition, this is another one of those times where it's good to consult probably an appellate lawyer who can advise you on whether it's a good writ or not. I spend a lot of time talking people out of pursuing writ petitions, but also sometimes they're really good candidates and we do them. So those are writ petitions. There are also some statutory writ petitions, for example, challenging the denial of summary judgment or a summary adjudication ruling. I mentioned those only because I said that there was a 60-day deadline before. For the small category of writ petitions that are by statute, the deadline is shorter, often 10 days or 20 days. So just know that sometimes the clock is running faster. And the last thing I'll touch on just briefly before we take question is stays. People often call me and say, I filed a notice of appeal. Is everything stayed? And the answer is generally, it depends. The statute to look at is Probate Code Section 1310. The default is that an appeal stays operation of the appeal judgment or order, unless it ordered payment of money, in which case you probably need a bond to stay it. While something is stayed, a court can direct the exercise of fiduciary powers or appoint a guardian or a conservator or an administrator or a trustee. And all of the acts of the fiduciary pursuant to directions of the court will be valid, irrespective of what happens on appeal. This is kind of protecting whoever needs to be making decisions while the appeal is going, in recognition that sometimes things need to keep moving along. And so this is in Probate Code 1310, but good to be aware of the parameters of what can happen while an appeal is pending, because an appeal can otherwise really tie things up for a couple of years, which, depending on which side you're on, can be advantageous or not. So I think with that, it's a lot of information I've given you to digest. I don't want to try to cram any more. I will say I send out a monthly short little tip for litigators with an eye towards appeal. If anyone is interested in getting on the circulation list for that, you're welcome to email me after the presentation, and I would be happy to add you.
And so I just wanted to point out and remind everyone that the CLE materials and the program materials, excuse me, are in the chat. There is a link to download them in case you didn't notice. I saw a couple questions on that. So those are there. So if you wanted to go to that, please do so and download it. I believe it's also included in the emails that the Beverly Hills Bar Association sends out. There is a link to a Google Drive that has all the materials that Alana shared with us that are related to today's program. I'm just looking at the question and answer box. I don't see any specific questions other than the one about the materials. And so, Alana, unless there was anything else you wanted to kind of close with, I'm happy to just thank you for your time. Thank you for your expertise. Please do reach out to her if you would like to be added to her newsletter. It sounds like a great kind of up-to-date tips and tricks for litigators to keep on top of appellate issues. But with that, if there's nothing else, thank you for everyone's time. Have a great afternoon. And Alana, thank you once again for just a great program.
My pleasure.
All right, take care, everyone.
Thanks, everyone.